And we are live. Hey, everyone. Welcome to Legal Bites, where we explain the law one bite at a time and hopefully explain it well enough so that you can make intelligent decisions for yourself. So we are obviously going live today to talk about the Gabby Petito case and the Ahmaud Arbery trial and the hilarious lawsuit between Todd Chrisley and Katie Joy Paulson at Without a Crystal Ball. It seems like Nate is probably running late, so he'll probably join us in a little bit. But we have so much to talk about. I mean, there's also just been a lot of legal news lately, right? Like there's just been like the Parkland High School shooter just pled guilty.
I watched that plea allocation for whatever.
Was that yesterday or
yeah, it was the whole. I watched it yesterday. I watched the whole hour of it, so that was interesting.
Yeah, so there was that. The Elizabeth Holmes trial is in its like 6th or 7th week. Vanessa Bryant is fighting over, evidentiary issues with the County of LA over the photographs of the helicopter crash site where Kobe and their daughter also died. So there's just a lot going on in the law right now. But I figured these three are good to talk about, to kind of focus on this week. So let's get started. Brian Laundrie, just kind of really quickly on this one. Brian Laundrie, it seems, has been possibly found, right? It hasn't been confirmed, but yesterday the FBI had a press conference where they said that human remains were found in the nature reserve in Florida where he was supposedly hiding out, or he had gone hiking and was attempting to, I guess, hide out and live as a survivalist. People were saying, "Oh, here's Nate. It's Adam. Hey, Nate, how's it going?"
No.
Oh, you're muted.
Sorry, you guys can hear me all right?
Yeah, there you are. Cool. So, so I just started talking about Brian Laundrie and how his remains may have been found. So, it's interesting to talk about because, of course, instantly there have been a ton of theories about his parents because people have been searching for Brian Laundrie for weeks. There's been a whole manhunt that's been going on, and now his parents, I guess, contacted the authorities on Tuesday saying that they had an intent to go on Wednesday into the nature preserve to sort of help find him, and within like 30 minutes found him. It's a little suspicious, of course, but without actual evidence, whether or not they have some sort of criminal liability is not necessarily likely, right? There's got to be evidence of that before people can start accusing them of something. But so they found remains next to a backpack and not far from, I guess, another bag that was known to be Brian Laundrie's, and the backpack was also known to be Brian Laundrie's. And apparently the father found it just a little bit off the trail. He found the bag, not the backpack. So there's a lot of theories that specifically that the father planted that bag to make it look like that bag,
If they did that, now we've got now we got some real criminal problems. You go for accessory at that point.
Yeah. Right. But the thing about that, though, is that I believe the father had some media that was not far behind him, and also law enforcement officials that were not far behind him as they were slowly going on the trail, sort of proceeding through the nature preserve. So I don't know what this bag looks like, if it's small or large, if it's the kind of thing that he could just sort of have in his pocket as he's walking, or if it's large enough that someone else would have seen it when he went on his way in. You know what I mean? Have you guys heard about this issue?
Not particularly, no.
I haven't heard it, no.
Okay.
I'm pretty far behind the Brian Laundrie thing because I know they found human remains and the backpack and stuff, but
yeah,
have they? Well, obviously they're probably going to just run DNA, right, on everything and find out. So
yeah. So the thing about the remains is they said that the remains were found in an area that was previously underwater. So that's one reason why it would suddenly show up in a way that it hadn't in an area that they had already checked that it wouldn't have shown up earlier. And, you know, the medical examiner is obviously going to be doing an autopsy on this body, and they will be determining a cause of death and also what has happened to these remains since it died. So if it has been underwater for however long that you know, he's been missing, you know, then that would tend to potentially corroborate this being an honest happening, right? Like that is not something that the parents were like, oh, let's sort of plant things in a way that maybe it's not him, but we'll make it look like it's him and he's escaped somewhere else or something like that. So there's been, and up to this point, I know that there have been a lot of theories on Twitter and elsewhere where people are talking about maybe he's hiding out in their garden and like they created some kind of a bunker for him. And, you know, like so many really wild theories, you know.
The bunker might be a bit much.
Right. I would think so, because at what point would they have it?
What point would they've dug up this bunker? Had they been digging up the bunker now and like no one somehow noticed?
I mean, in order for that to have happened, like they would have been premeditated, right? Like on this whole thing, like, yes, you are going to go on this road trip and this is what you're going to do. And then you're going to come back and you're going to hide in this bunker. Like it seems a little bit far-fetched, right? So given that, I wouldn't necessarily treat, you know, the fact that it is a theory that people have, you know, treat it in a way that people are, you know, that it has much merit. So
it seems this seems like they're trying to insinuate that this may have just been a suicide, so right, or something of that nature, right? That he just went out there and did something or something.
Yeah, I mean, it could be, but the medical examiner will tell us that, right? They'll tell us the manner of death, if it was a suicide or if it was, you know, because there are a lot of animals in there that can kill a person, right? Like this is Florida we're talking about. There
That's
are
true.
All kinds of crazy wild beasts in the swamplands of Florida. So in all possibility, he also could have been killed by something that was, you know, by some animal or some other person, who knows. So it'll be interesting to see what happens when the medical examiner comes out with his or her report, and yeah, we'll go from there. But it sounds like it's going to take a little bit longer just because of the condition that the remains were found in.
Yeah. So
anyway, but yeah,
it's interesting. Well, quick question: Do you guys think that it is? Do you guys think that if it is him, is this close the case? Like, do you think it goes on? Because essentially, I think everybody thinks that he did it, right? I think this kind of ends the investigation. No,
I think it probably would most likely end the investigation. I mean, I think maybe there would be more questions for his family to see what all they knew and whatnot, but I don't know how much further than that it would go, unless they have some information that they have not made public that would be salient, you know.
Which is quite possible.
Yeah.
So, yeah. I guess we'll find out as things go on.
Yeah. I like KM. KM said Epstein didn't kill himself. That's so true.
That is maybe true. I have no evidence for or against that.
I think there's some evidence against it in the public record. Yeah. I've gone through it before. It doesn't smell right at all.
Yeah, but that's a whole other can of worms, right?
Yeah.
Whole can of all kinds of different worms, like yeah. Anyway, which
in legal news, which we were mentioning earlier, like the prince is still in legal trouble. I think there's news about that recently where they're trying to get further information from him as a result of all that stuff.
From who?
For Epstein.
Oh,
for
Prince
related
Andrew.
to that. Yeah.
Oh.
I think there was rumors of like some kind of indictment and stuff coming down recently. So this is like, it's still progressing apparently.
Yeah. Interesting. I mean, I don't know. I've never seen how that works with trying to depose a foreign sovereign? Because I know that, if it comes to a diplomat,
He's not the sovereign.
well, but okay, sure, but he's part of the royal family, right?
Yeah.
He hasn't stepped away from the royal family. So that's
You're talking about Prince Andrew, right?
Yeah.
Right.
Yeah, but well, is he a diplomat? Would he be? I think he does. I think he gets that immunity.
You think so, under the Vienna Convention?
Well, because don't forget, it's not only the sovereign automatically gets the different diplomatic immunity, right? But their head of state is essentially the royal family. So Prince William, all those, and when they travel, I'm assuming they also probably get that head of state treatment too. Like Prince Andrew, when he comes to the United States, I'm thinking he'll get virtually diplomatic immunity if something was to happen. No.
That would be an interesting question to research, actually. I have not thought too much about that, but now that we're talking,
let's move on to other subjects before we get too bogged down.
I know. I'm going to make a note of that for later. So anyway, but I think we've probably covered the Brian Laundrie situation enough. I wanted to touch on it just because it literally just happened yesterday. So, that seemed pretty salient. So anyway, let's move on to the next topic, which is Ahmaud Arbery. The trial just started on Monday. They've been trying to seat a jury. So we'll get into the actual case itself, because I know Uncivil Law has become the world's leading expert on this case with the number of videos that you've made on this subject. But first we'll talk about this issue that kind of came up with seating the jury, which is that this was reported by Vice News, and I don't know, it sounds like it might be kind of more of a they're kind of sensationalizing a nothing burger a little bit, because they said, so Vice News reported that the court has mistakenly given potential jurors access to Ahmaud Arbery's mental health history. So what they're alluding to is that the court website, they have directed potential jurors to the court website to find when and where they're supposed to show up in order to go through the voir dire process. And Vice News reports that just a couple clicks away is where you can access the documents in the case, which includes documents that talk about evidence of Ahmaud Arbery's mental health history, which the judge has already determined is evidence that will not be admitted at trial, because the relevance is not outweighed by the
prejudicial value. Yeah,
prejudicial value. Thank you.
You can take care of that voir dire.
Yeah, exactly. So, so their whole point is, that this is a way that jurors can be disqualified if they access this information, and if they somehow make it onto the jury, then it can result in a mistrial. The likelihood of that, though, knowing that this information is out there, and truth be told, now that people are reporting on it, Vice News reporting on this issue probably ironically makes that likelihood higher, because who would have thought to go to these documents to find this information, unless this is like a cyber sleuth, someone who's super interested in getting like all of the information in this case to sort of make a determination ahead of time, in which case they may or may not be biased, right? They may already have a certain emotional pull on this case. So the irony of this reporting is that they may actually make that more likely that potential jurors would encounter evidence that they shouldn't be encountering because of this reporting. So, and then they talk about, a couple other details, which I actually won't say, because if someone in Florida is watching this and then gets called as a potential juror, then I would be doing the exact same thing. So anyway, certain details that could be potentially prejudicial. So anyway, what are your guys' thoughts on that? Have Nate, you've gone to trial before, right?
Yes, I have, but I wasn't first seat. I second seated both the trials that
Yeah.
I was in.
Yeah. Have you ever seen anything like, where a juror has, I mean, it's obviously it's much more likely with a national case. But seeing a situation where a potential juror has already accessed too much information.
Yes. When I was at the DA's office at the beginning, they would what they would do is have us watch the more experienced DAs handle trials, and voir dire was one of those things that we'd watch. And it was interesting because sometimes there were a couple of press cases that it had hit when I was there. And sometimes the jurors will say, yeah, I heard about this in the case. I've done a little extra research and that type of thing. But that's what the general jury questionnaire was about. Hey, have you heard anything about this case? Have you looked everything up? And now I think a lot of times too, now people are scared because you can go back to their social media history and find that, hey, you've looked this stuff up or whatever. So most people yeah, it can. And it's always tough with juries too, because, unless they're sequestered, they're still after day one when they go home, if it's a hot case, then everybody's going to kind of know everything. And especially in that local community where it's not like New York, where there's 8 million people, but a local community like that, where this is front page news. This is going to be on the local news. Ahmaud Arbery's trial start, pulling jurors from the local area. So I think it's just going to be a lot tougher there. But we'll see. Just like it was in the
Derek Chauvin
Floyd case. Yeah. It's just sometimes you're just not going to find people who have not heard about it, but you're trying to limit the damage that it can cause to both sides through jury questioning.
Yeah. And you always hope that the jurors are being honest when they talk about what they've seen and what they haven't seen and different reservations that they have, because I know that in the Elizabeth Holmes trial this week, they had an issue with the jury because they've been at trial for 6 or 7 weeks now. And apparently there was one juror who just now this week, or maybe at the end of last week, said something along the lines of that she's Buddhist, and so she felt like she couldn't sit in judgment of another person. Which I don't know why that takes 5, 6, 7 weeks for that to come out.
What did this happen? What exactly did you become Buddhist, and what?
Yeah. So it could just be that she was just tired of sitting at trial for that long. Which is really, really unfortunate because obviously
I would be tired of sitting a trial for that long.
Yeah, of course. Especially
as a juror where I can't do anything. Damn.
Yeah.
that's boring.
Yeah. I completely understand that. But this idea that, because of her religious objection, assuming that she was the same religion that she was before, right? So
she found Buddhism in the last 7 weeks, I guess. That's actually an interesting, actually a quasi-plausible thing that could have happened. The trial got to her so much that she started seeking solace anywhere she could find it. Buddhism was the answer. Maybe.
Or maybe the actual the details of the case made it a situation where she felt like she couldn't conscientiously make a decision. Or something like that, it may be that the details are worse than she thought, I guess, which would
But the thing is that I think that cuts both ways, because I would want a juror who is having those type of issues, because we have alternates, right? There should be alternates there. So if there's an alternate, then I would say, like if we have less alternates, then we're going to try to see if we can save what we got. But if there's an alternate, okay, I would rather them be honest and say, I'm having an issue, I can't come to a conclusion in this case, than be forced to do it.
That's true. That's very true. On the other hand, I think that they did end up swapping her out for an alternate, and I think the alternate said, my command of the English language is actually not that great, which is difficult.
How did this not come up?
Yeah.
How did this not come up?
Yeah.
I would imagine there was an extensive jury questionnaire.
Yeah.
And answering the questionnaire is different than actually communicating, and because she may be conversational, but not deep, things like that.
And especially in a case like this that seems to be pretty technical, when they're talking about the Edison machine that was supposed to do all of these amazing things with blood work, with tiny samples of blood and whatnot. So it could be that his or her command was good enough, like Nate said, to be conversational, but not necessarily good enough for this highly technical kind of stuff.
Yeah, and I would think I would want somebody who knows the English language. If I'm the defendant, I want somebody who knows what's going on. You know, so,
Well,
or it could go the other way.
Either
too.
way,
It could go
yeah.
the other way, right?
We do have to be a bit cautious there, because that line of argument could run you into the problem where you're like, you know, someone who's a native born American, but, you know, is blue collar. I mean, the technical details might be a problem, but so like at that point, are we saying that you have to have a certain level of education or a certain level of, you know, whatever to be in the jury? And now we're not just in a broad jury of your peers. So there's a problem there with that line of argument.
Well, but I think the argument is more a command of the language versus a command of your educational status, right? Because anybody, like it doesn't matter. But if you're saying that I can't, you know, I know certain words, I can communicate with you. You know, can I have a sandwich? You know, how much money do you have? But then when you start talking about things like those, you know, because legal terms, juries, and you know, evidence and things of that nature, it's like you know, my understanding of the language doesn't allow me to really interpret those things easily, unless I have an interpreter.
Right.
I guess it depends I guess it depends which in those we mean. You know, is it that I literally don't understand the words in like a literal sense, so I don't know what that word is? Or is it that I don't understand what the word means? Because if I don't understand what the word means, but I know what it is, then we run into problems with native-born Americans who might not understand what certain words are. I don't know. There are a lot of people who at the start of this thing knew what, you know, a lot of these technical terms are. I mean, this is also coming from the perspective of a patent lawyer, mind you. And patent lawyers have juries, which are juries of the peers. And it's hard to get much more technical than that, than the patent lawyers. So you know, the patent lawyers have to deal with this problem all the time, and they still deal with a broad swath of a jury of the peers. So, you know,
which that is,
we,
I mean,
we make do.
At the end of the day, I mean, educational level, you know, and IQ and whatnot shouldn't really be too big of an issue for seating a jury, because at the end of the day, that is the lawyer's job, is to make sure that they are communicating their case, communicating their narrative, communicating the details of their narrative to the jury in a way that they can understand. I mean, it's not terribly unlike what we do on our channels, right? Is to break it down so that anyone can understand.
Yeah.
So, but anyway, back to Ahmaud Arbery. So aside from this this jury issue, let's get into some of the details of the case, because I've never talked about it on my channel, but but I know that most everyone probably knows about this. If you don't remember, he was a young man who was, I think, 25 years old, went running, got curious about a piece of property that I think had some construction on it, and kind of was walking around. Curiosity, you know, this happens with a lot of people. I've gotten curious about properties when I've seen stuff like that. You know,
I've gone to partially completed houses many times. Interesting.
You know, this kind of stuff happens. But you know, he was in a neighborhood that was middle class white neighborhood, something like that, and he was African American, and so he was followed by a father and son duo in their truck, and then they ended up performing what they say is a citizen's arrest that went wrong. Their neighbor ended up joining them, filming the whole thing, and partaking in the activities.
If you know what, I can screen share the whole thing. It's like 15. It's like, what is it? A minute, and it shows like the whole thing. It's about him going into the house and everything. So
okay, let's do it.
Screen share this. Oops. Sometimes I hate StreamYard. Sometimes I love StreamYards. Actually, I love them more than I hate them. It makes it just so much easier. All right, here it is.
Okay.
So I don't know if you guys should be able to hear this. So here was just the events as they unfolded. So we're looking at video footage from a house across the street from the location in which Mr. Arbery is alleged to have gone in. If you look at the upper right-hand corner of the screen, you'll see Mr. Arbery come into camera view. He'll stop in front of the property, and then he enters the property. This is a video of him entering the property, and him inside. He looks around, and that's it. Now, while he's in the property, you'll see in the upper left-hand corner somebody walk down the street, and this is our 911 caller. This person is going to make a 911 call. Oops.
Yeah.
We got to add, but here we go. It's the 911 call. I linked up the 911. So here is the 911 call synced up with the surveillance footage. So let's see if we can watch exactly what happened in real time and listen to the 911 call.
Glen Brunswick Communications, Operator Smith.
Hey, I live out in Steel Shores.
Okay.
There's break-ins out here. There's a guy in the house right now. It's a house under construction.
Okay, do you have your address or the other house's address?
Right at Castilla Drive.
And you said someone's breaking into it right now?
No, it's all open. It's under construction. And he's running right now. There he goes right now.
Okay, what is he doing?
He's running down the street. Call
Okay.
Back into the
Okay, that's fine. I'll get them out there. I just need to know what he was doing wrong. Was he just on the premises and not supposed to be?
Stuff on it. And he's been caught on the camera a bunch before at night. It's kind of an ongoing thing out here. The man that's building the house has got heart issues. I think he's not going to finish it. So.
Okay, that's fine. And you said it was a male in a black t-shirt?
A white t-shirt. Black guy, white t-shirt. And he's done running back into the neighborhood.
Okay, and...
My front yard.
So now, all right, so that's pretty much it.
Your hair looks different.
Oh yeah, I it's got longer now. It's got longer now.
Your COVID hair.
So now so essentially this was trespass, and the reason, and the simple reason why is because there were many here, like there's video of other people going into that house even on the same day, right? There was actually this was a frequent occurrence. Here's a video of other people going to the house. This was like a really, really frequent occurrence there. There happened to be a water
Probably
source.
why they have those cameras in there.
Yeah, there was a water source actually in front and behind the house. I don't know if you guys can see this, but there's a water source in front and behind the house. So here is the video of other people.
Surveillance video showing people frequently coming in and out of the house, including children. A white couple entered on the day of the shooting.
So this wasn't like, and I think they had something like what? It was over like 50 people or something they had going in and out of the house and something like that. So this was a frequent thing because there was a water source. So I know the first thing that people are going to talk about is whether this was a burglary. And if it was a burglary, because essentially in Georgia, you can arrest people for felonies, right? Citizens arrest, you can arrest them for felonies. And here the argument is that this person was committing a burglary. And that's and now if you can say this person was committing a burglary, then that kind of gives these other guys some type of leeway to then arrest him because he was in the commission of a felony. I don't think we have that here. I don't think you can make the argument that this is a burglary. I think this is a for sure trespass, but burglary.
It's hard to be a burglary when he didn't take anything. You could try to argue attempt, but in order to prove attempt, you'd have to prove his intent. Which how? So there's no evidence to support burglary.
Right.
Well, how do you? Go ahead. I'm sorry, Alina.
No, I was going to say I do agree. I mean, also just to clarify, the guy that made the 911 call is not one of the defendants, right?
No.
So they were seemingly nowhere to be found when this was happening, or did they see him? They saw him enter the house, right?
No,
somehow.
no.
Were they just not?
No, they didn't see him. The guy saw them, and when he saw him run out, the other guys were notified that this had just happened, and they jumped out and got into their truck and chased him. So they actually didn't see him go into the house, all that other stuff. They just it was for them. It was on hearsay.
Someone in chat says burglary doesn't require theft. Does burglary require theft?
Yes.
Burglary, well, in Georgia, it requires theft or the intent to commit a crime therein.
Thank you. Moving on. Two other lawyers agree with me. Okay, let's move on.
If I'm going in there to commit some type of crime, then yeah, but you have to explain what that crime is. You got to, if like for instance, his girlfriend lived there and he went in to go beat up on his girlfriend, then he's committing a burglary even though he's not stealing something. So that's the thing that separates burglary from trespass. Trespass is I go on the property and I come out. Now
you're on someone else's property and you're not supposed to be there. You don't have permission to be there.
Now, a lot of these conservative sources are trying to make every trespass into a burglary, but I don't think those kids who went inside there, just like Ahmaud Arbery, they would, essentially you'll be saying they committed a burglary, right? You're saying the couple who went in there to go have relations, we're going in there to have a burglary, right? Obviously that's it's too broad, and what you have done is essentially erase what trespass is. You turn all minor trespasses into burglaries in this particular sense. So,
right, and so that would, and
it wasn't posted because I recovered this case a lot back in the day. So you can get felony trespass if it's posted, but it wasn't posted. So
you mean if
partially entered house, it's a misdemeanor trespass, I guess, maybe, and even that's debatable, incidentally.
So. Okay, so just to clarify then, so it seems like the prime defense that the defendants have in this case is that they were performing a citizen's arrest, right?
Mm-hmm.
Yeah.
So interestingly enough, back in May, the governor actually repealed the citizen's arrest law in Georgia, which Kurt and I were talking ahead of the live stream backstage that Kurt actually informed me that pretty much every jurisdiction has a citizen's arrest law, including California, which is always fun when Kurt tells me something that I don't necessarily know about California law. But that apparently it goes all the way back to, you said, medieval times.
Yeah, it's medieval English common law.
Wow.
With this, yeah. So a lot of states don't necessarily have it as a statute. So they would have it as common law. It's non-codified, we call it, when it's not in a statute. So when it comes to statute, it's codified. So Georgia, presumably, although I don't know for sure, but let's say yes, Georgia had a citizen's arrest probably before. They had it before 1851 or whatever. Oh. But in 1851 or whatever, they decided to codify it for some reason. So okay. Yeah, so citizen's arrest goes far back.
The something else about the reporting on this is that when I came across an article about that, the headline said something about Georgia governor signs the repeal of citizen's arrest law that was signed into law in 1863, which of course, as soon as you give a date like that, that's really right after the Civil War, that puts in anyone's head oh, this is obviously a Southern law that's intended to be a holdover for the Civil War, for slavery and
if if you're an idiot, right? It's it must be slavery. I'm no, it goes back a couple hundred years before that, and in a completely different country, and it exists basically in every single state except now Georgia for some reason. Yeah, every state has a citizen's arrest statute or citizen's arrest common law. So. No, there's nothing. No. But it must be racist. No. And I don't understand why they repealed it completely, because it doesn't even make sense, because whether it was citizen's arrest or not in the past can't change in the future. You can't, by repealing the statute now, change what happened in the past, because ex post facto. If citizen's arrest was a valid defense in the past, which no, you can't repeal the citizen's arrest statute and say it's no longer a defense. You can't do that.
Right.
So
it would go
it doesn't matter either way.
From the date that it was repealed forward, then as to any kind of act that's going on after that date, then there would be no citizen's arrest defense. But for this particular case, it's actually not terribly relevant, because they still have that defense, because that defense existed at the time that they committed the acts that they did.
It also doesn't make any sense for my money going forward, as if it's truly a universal striking. That's what they did. They repealed the whole thing, right?
I think so.
If they repealed the whole thing, then that would seem, I guess that means the common law is dead now too, because it was codified and now not. So I guess there's no common law left. So let's think about how this would apply in the future. You're a security guard. You're paid by a company to watch out for people committing thefts. Someone tries to commit a theft. You stop them and hold them for the police. Now you're guilty of a crime. There is someone snatches a purse from a woman. The woman says, "Stop him, stop him." You stop him. You've committed a crime?
Yeah.
I don't understand how this, you're not only can I not act, because the law always says you don't have an affirmative duty to act. So if the old woman says, stop him, and I can be like, yeah, screw you, lady. Ha ha ha. Just laugh in her face if I want to.
Right.
But that's my option. But now basically I have to do that because I don't have the choice to act because I'm incurring criminal liability. So how am I
wondering,
I'm a lawyer in Georgia now. How am I supposed to advise my clients who are security workers? How am I supposed to advise my clients who are managers at stores? What am I doing now?
I wonder though if there's an exception to the repeal, that if someone is in like a specific role that they are like a security guard, for example.
Here it is. I was looking at.
Yeah, please tell me there's some sanity. Please tell me there's some sanity to this.
Yeah, HB 470.
Yeah, House Bill 479.
Yeah, would remove
I'll share my.
Would remove citizens.
Can you share it with us? Yeah, share it with us. Let's all read the statute together, like good lawyers.
Yeah.
We'll read the words like a lawyer.
Here we go. Okay, so this is the bill. Okay, as passed.
Purposes, blah blah blah. Skip.
Yeah. Section 1. Let's see.
Skip.
Section.
They're
2.
adding in stuff. Section 2.
Yeah.
Oh, up a little bit, please. Okay.
Essentially, it's from what I'm reading here. It's saying that you can still arrest people if you're on someone else's those for conducting businesses on someone else's property.
Dealing with
security
officers,
officers, private investigators, inspection on truck scales can detain someone who they believe committed a crime.
Scroll up to the top of this section.
Law enforcement officers to make arrests outside of their jurisdiction.
Yeah, so Section A1 deals with law enforcement officers, so we don't care about all that.
Yeah.
So we can skip the entire section. Keep skipping.
Okay.
Keep skipping.
Used in this article.
Okay, private person may detain an individual if such private person. Okay. Owner of retail establishment, reasonable. This stop. Individual sought has committed a crime of theft. Okay, great. Owner of a food service establishment, individual sought has committed theft. Owner of any business owner property, weight inspector, licensed registrant. Okay. Section C, got it.
Private person who detains an individual under this code shall either release that individual or within a reasonable time contact the law enforcement unit with appropriate jurisdiction. An individual detained by a private person under this code section who is not released shall be surrendered to a law enforcement officer together with any personal belongings removed from such individual. So basically, that sounds fairly reasonable, right? That you can only apprehend someone. You can't do anything more than that. And you can only do that until law enforcement, you call
Which was pretty much the old statute anyway. But
was it?
Effectively. It was. But what narrows here is that this only applies to owners and shopkeepers and businesses by a statute. So, okay, fine. We can take away my example of the person committing the theft, and we can take away my security guard problem. So that's solved. Thank God.
But you know what?
But I'm still back with the old lady on the street. How about my old lady on the street? I literally can't stop the purse snatcher. Nothing in here is protecting me.
Well, look, I think you can, because don't forget you still have self-defense laws for the protection.
Well, in this hypothetical, I'm not at risk, so it's not self-defense, and the purse snatching has already happened. So there's no risk to women, so I can't defend others.
But there's defense of others too.
Yeah, there's defense of self and defense of others. But if the purse snatching has already happened and the person's running away, you can't. This is not chase them down and grab them. And one thing I think a lot of people don't understand is that this law, that they changed this law, and this is why I think sometimes the racial component to these things gets so drowned out in the actual thing that's happening. We have Republican Jeff Kent who signed this bill on behalf of Ahmaud Arbery, right? This was because of what happened to Ahmaud Arbery. They changed this and said, this is too broad. This is not right.
Right.
One thing with citizens arrest, a lot of people don't understand, is just because you have the ability to arrest someone, a citizen's arrest is extremely dangerous for the
Right.
person making the arrest. And what I mean by that is, if you are wrong, you've just committed major felonies. If you arrest somebody and it happened not to be accurate, you've got kidnapping, you've got possibly assault, you've got possibly you've got a lot of different charges that you will be charged. Just the same thing that they're doing here. If the person is killed, you now have felony murder because you were committing a felony of false imprisonment, and then the person died. So that's here. I think by making it very clear that you don't have the right to arrest, to conduct these citizens arrests, I think that keeps it where people who do have that authority and do have that training to make these arrests, because a lot of times when you're trying to arrest somebody, it does take training. Like they send you to years worth of training to know how to put handcuffs on people, to know how to take care of people when they are your prisoner, to know how to move people. So it's not just like, a lot of people think it's just like the movies, right? You're under arrest and put handcuffs on and you're good. There's a lot more to it than that. But I think at the end, this law protects the citizens, those people who want to do the right thing. Because why? You can just pick up your phone and make a phone call. And I think that's the world we live in 20 years ago, when people didn't have cell phones. Citizens arrest may have been more necessary for like your women with a purse, example. But today, when everybody has cell phones, police contact is just like that. And make it a
police response time, though, especially with the whole defund the police.
Yeah.
Right. So I have cell phones to call the police that now no longer exist. That's great.
Well, they exist, but
yes. I was being hyperbolic for the point of the example. Yes.
So well, I'm glad that we went through that, because that's a very interesting aspect of this case that Georgia has eliminated the previous law. But I think it's good. I think it's a good replacement from a policy standpoint, because it means that not just anybody can go and arrest someone for some crime that they think that somebody else has committed. And it really clarifies in a lot of ways who can and who can't. And that's always good. That's always a good thing, right? No matter what we think politically, or not politically about this particular case, like, it's always a good thing to have that sort of clarity.
I think the old law was perfectly fine. I looked at the statute before many times. I think it was perfectly fine. It had to be committed in your presence, or it had to be a felon. Either it was a misdemeanor committed in your presence, or it was a felon that you knew was a felon, so you could arrest them escaping or something like that. So, I think the old statute was perfectly fine. And I think to take away the ability of people to act when the situation calls for it, or to impose criminal liability, because as a lawyer, I have to, if someone comes to me for advice in advance, I would give the most conservative answer, right? Because I want to protect my client, right? So what is the most conservative answer? Like, it's probably true the prosecutor won't prosecute you. It's probably true that a jury won't convict you. It's probably true, but can I guarantee you that? No. So if you come to me and be like, hey, by the way, in the future, if I happen to be in Georgia and I see someone snatch a purse from an old woman, she yells, help, 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 and the purse snatcher is running towards me, I can stop him. Should I stop him? I guess I'd have to say, no, you shouldn't stop him. You should let him pass. Which seems, not only should you, you must.
Well,
you must let him pass.
Call 911. Right? If you can't call 911,
take a video.
Take
a video, yes.
Right?
But I can't actually stop him if I were so inclined. So and this law exists basically the same way in every jurisdiction. I don't know why this is a specifically Georgia thing. It doesn't apply to the circumstance. I don't get it. Nothing makes any sense.
I'm thinking they wanted to change.
I don't approve.
I'm with you, Kurt. Because just so everybody knows, the way it works here in New York is that if you're making a citizen's arrest, you can do it one or two ways. If you witness it, right? If you are there, just like Kurt says, if you are there and you witness it, it's happening right in front of you, you can effectuate that. And for felonies, it doesn't have to happen there, but you can still, for felonies, you have a little bit more leeway. But in both situations, though, you have to be absolutely sure to get any type of protection from the law, because the law is very clear. You know what I'm saying? And I think the Georgia law is very clear. And unfortunately, it got messy because of the fact that he did commit a trespass. I'm granting that 100%. He did commit a trespass. And I think people were assuming that you can arrest someone for committing trespass even if you didn't see it. And that's just not how it worked in Georgia. And that's why these people are being prosecuted, because you can't.
And even if you can't use deadly force to effectuate the misdemeanor arrest.
That's
right.
true too.
Right.
So there was a whole bunch of problems.
That's
even
another issue, right? Is that so even if you say, okay, so first you have these series of questions that you have to answer in order to determine whether they are guilty or innocent, guilty or not guilty, I should say. So first, was it a citizen's arrest? Was it a proper citizen's arrest under the elements under the statute? Was this a crime that they saw right in front of them? Well, we see no, that doesn't appear to be the case. But even if it was, would that justify them killing him? Because
not only
most
killing him, but using
trespass.
deadly force. Yeah, using deadly force, and the mere possession of guns. When you're out and about, it's the use of deadly force. It's like, because there's the threat there. It's like, yeah, this is a threat. They were holding the weapons in their hands in a posture is brandishing. It's an offensive posture. So it's like, oh, this is stand your ground. I'm like, no. This is self-defense. No. None of these things. I'm a huge Second Amendment advocate. I love the Second Amendment. I love citizen's arrest. But just know, you're all stupid. None of this makes any sense.
You're all stupid. Well, I wouldn't say that.
I got a little bit frustrated because I had a series of videos, as the chat was sort of alluding to. I had a series of videos where I was arguing with one guy for like 3 different videos on what escape meant. He was escaping. He wasn't escaping.
Did you ever consider the possibility that you may have been dealing with a troll?
No.
That's true.
Well, either way, it got like 3 different videos out of me, as I think I read every single Georgia case describing escape and went back into Westminster common law, trying to show this guy, no, this is not escape. In order to be escape, he has to be in some sort of custody of some variety, constructive or otherwise. And it's like, no, that didn't happen. No, stop talking. So yeah, I thought none of these arguments made any sense from day one. I was surprised in reading at the articles in the timeline that one of the prosecutors apparently said there was no cause. I'm like, what? Or like other people had problems with it. I'm like, I thought this was easy. It seems easy to me.
Now that's another question that I have for you guys. Why do you guys think that they have not pled guilty on this case? Because
during
to
nullification,
me, I'm a little bit surprised that they haven't, because of the fact that there's video evidence. There's this 911 call with video evidence of that and audio and whatnot. It's pretty clear that they were not there when the crime, the trespass happened. So it doesn't meet the elements of a citizen's arrest under the old law. What do you guys think about that?
I don't get it.
Yeah, I don't think the old law didn't give them, from my understanding, the only way the old law would give them any type of cover is if Ahmaud Arbery committed a burglary. Then I think you may have some argument to whether you were effectuating a citizen's arrest and whether he's resisting. That you possibly could have that. But then you still have to worry about, well, did you guys didn't witness it, which reasonable grounds, that type of thing.
Yeah.
But I think their argument is going to be simple, is that they're going to say that Ahmaud Arbery had committed this crime. And because he was committing this crime, they were trying to take reasonable measures to effectuate that arrest. And I think they're going to say that them standing there with guns, because that's what's going to come down. Were they lawfully justified to brandish weapons and order him to stop what he was doing, right? And if the jury comes back that says that they were authorized to do that, then it's going to be not guilty. If the jury's going to say no, they weren't authorized to do that, then I think you're going to have a conviction.
Interesting. So Michael Oninas here says that one of the lawyers did an appearance and outlined their defense. They're relying on the arrest statute and then self-defense.
No.
They argue they had reasonable belief there was a burglary.
No. That's not enough. It doesn't. That's not the citizen's arrest statute. For the officer statute, yes, you can talk about probable cause, but that's not the way the arrest statute is written. It has to be committed in your presence. You have to know it. And it's like,
and each of those elements has to be met.
Reasonable belief does not work.
Yeah, just so everybody also understands too, is that we live in the United States. In the Fourth Amendment, an arrest is a seizure under the Fourth Amendment. So you cannot arrest someone under a reasonable belief standard. That's not the standard for a seizure of a person on arrest. It's under probable cause. And that's what the citizen's arrest statute is more or less pointing to. You have to have probable cause to effectuate an arrest. Now that's for everyone, for police officers, for citizens, for everyone. So if you go to court and say, well, we reasonably believe this person committed a burglary, that would not be enough. You have to have probable cause that the person could have committed a burglary. Then you may be able to make that argument. But again, they didn't have probable cause because if you again, when you look at the other examples, the kids.
Can we pull up the old Georgia statute?
You just don't get it.
Or should I pull it up just to see the old Georgia citizen's arrest statute?
Yeah,
I have it here. I'll pull it up.
Yeah, let's pull up the old citizen's arrest statute because we keep talking about it. Let's actually read it.
Yeah, we might as well.
Share it with you guys,
so we can analyze it directly for everybody.
And you guys can tell me why my analysis has been wrong all these years.
And why that one commenter was correct after so many videos.
If I have to eat crow on that one, I'll tell you what, I might give up the game.
let me share this. This one. Boop. All right, that's it. Can you guys see it?
Yes.
Yep.
Okay, so private person may arrest an offender if the offense is committed in his presence or with his immediate knowledge. So yeah, you have to know. You have to know. Knowledge is know. So committed in your presence, you saw it. Your immediate knowledge, you know. So
immediate knowledge would be maybe you weren't in the room, but you heard it in the next room.
Or in the purse snatching example, you didn't see the purse snatching actually happen, but the woman's yelling, "Help! Help! Thief!" and you see the guy running with the purse. Then that would give you immediate knowledge. So you didn't actually see it, but you have knowledge. So mere probable cause, mere suspicion, mere guessing is not sufficient. You have to know. These people didn't know. They're toast. So next, if the offense is a felony, and that's why we got into huge discussions about the burglary, because no. And if the offender is escaping or attempting case, a private person may arrest him upon reasonable and probable grounds of suspicion. So, yeah, but it's not a felony, so no.
Yeah, it's
I don't
not
think
a felony.
We get to the second one, so you don't get the felony.
And then there's also the reasonable and probable grounds of suspicion, because if he's just saying someone else told me that he did this thing, is that reasonable? I don't think so. I mean, there's a reason why trial courts keep out hearsay without a proper exception.
Yeah, but this is essentially that's just a long-winded version of probable cause, reasonable and probable grounds of suspicion. That's essentially just probable cause. And generally, for those of you who don't know, to get probable cause, witnesses, for instance, if a witness says they saw you commit a burglary or something like that, you would be able to, you could use that witness's testimony as the probable cause to effectuate the arrest. But I think here, though, the problem is that he didn't commit a felony because you don't have a felony. You don't have probable cause even for a felony. And that's why I think the 911 call in this thing is important too, because the 911 caller asked the person, "Hey, what did the person do? Did he just go on the property and did just walk out?" And when
they don't have probable cause. Even you don't have probable cause for felony because you don't have the elements necessary to show burglary. You don't have any. So I've been apparently corrected in chat, intent to commit a felony will also work for in the case of burglary. So fine. So you don't have any proof of intent to commit a felony because how do you know what's in his mind? So it is burglary if it's intent to commit a felony, but how do you have probable cause of that? Because all you saw was him go in and come out. How do you show his intent from that? There's nothing clear. How do you show his intent to steal something? He didn't actually steal anything. So how do you show an intent to steal? You can't. So what is their probable cause? What is their reasonable and probable grounds to believe a burglary did occur? So he did have intent to commit a felony and he got spooked. How do you know? Or he, so it doesn't work.
Yeah,
it doesn't work.
Because unless the argument is just going into someone's house is enough to commit a burglary, that's you've literally removed trespass from the law. Then will be no such thing as trespass, because every time you go into someone's home, it's a burglary, even mistakenly too, right? Even mistakenly almost. So again, it's just people are trying to make the burglary statute so overbroad, so ridiculously broad, but it's just not that. So and the fact of the matter is,
people keep asking in chat, is burglary a felony? Is burglary a felony? Yes. We're not arguing that burglary is a felony. Burglary is a felony. We agree.
Yeah.
We just don't think that he committed a burglary, nor do we think that anyone can have a probable cause basis to believe he committed a burglary.
Yes.
He didn't actually take anything, so you can't prove it by him taking things. That would be a burglary. He entered into the house and he took something. He has it in his hand. You got burglary. But he doesn't have anything. So the only other way to get there is to show he either had intent to commit a felony or he had intent to take something. And you can't show that, because how can you show his intent for a probable cause? There's no way to do it. So burglary is a felony. We just don't think you can get there.
Right. And I mean, if they say, the intent was in the fact that he was running away, he's also wearing running clothes. If he was wearing a 3-piece suit, that would be odd to see someone in a 3-piece suit running. But it's perfectly reasonable to see somebody wearing running clothes. And somebody says his pockets could have been filled with diamond rings. There are no diamond rings in that place, right? It's a shell of a house. There are no personal items in there other than maybe equipment. Like if they had some sort of special saws for cutting the wood, the plywood there to create more walls in that house. There's nothing else there, So this is the burglary statute, because I think that there's a lot of confusion about whether or not this is a burglary. So this is at least from justia.com. I hope this is accurate, but this is what I found. So a person commits the offense of burglary when, without authority and with the intent to commit a felony or theft therein, he enters or remains within the dwelling house of another or any building, vehicle, railroad, car, watercraft, or other such structure designed for use as the dwelling of another, or enters or remains within any other building, railroad, car, aircraft, or any room or any part thereof. A person convicted of the offense of burglary for the first such offense, is going to be imprisoned for not less than 20 years. So you have to have the intent to commit a felony or a theft.
Mm-hmm. Right.
And
a police officer might be able to effectuate a stop, because the police officer might be able to do a Terry stop. Now, we could get into discussions about whether or not they have reasonably articulable suspicion or not, but the police officer has a much easier time of getting there. So the police officer might be able to stop him, to go and stop him. It wouldn't be an arrest at that point, incidentally. It'd be a Terry stop. And perhaps, ask some questions, at which point he could refuse to leave. But I seriously doubt that even the officer could get the probable cause and arrest. So the police officer being able to chase him down is one thing. The citizen chasing him down is different, because the statutes are different.
Mm-hmm. Right.
Yeah.
And there's also a question of whether it was a break-in. So I would say
it wasn't
no,
a break-in, because there was no breaking of anything. It was
right.
a house partially under construction.
Literally means that you're breaking a part of the house to get inside. But all of the doors and windows were open, because there were no doors and windows, right? It was just the structure of this place. So anybody could just wander through. Any people, any animals, like anything and anyone could wander through. So there's no breaking into this property. So, anything else you guys want to talk about on this topic?
No, I think a lot of people just this is one of those really technical, and the reason why the DAs and now the governor and everybody is on the side of Ahmaud Arbery is because it's clear that this was not a burglary. This was simple trespass, and unfortunately, I do feel I understand the other side, because let's say you're living in a neighborhood and you got people breaking into some type of house. You don't know who it is, but some of the houses may have been burglarized. Then you want to be kind of hyper vigilant. You want to try to help your neighbor, because that's what these were. Essentially,
Right.
let's just be honest with it. It's neighbors trying to help other neighbors, and trying to solve a problem. But I think they took a chance. They took an extreme chance of taking shotguns and trying to arrest somebody with not really understanding the totality of the situation. And when even 911 is telling you, don't chase the guy, we got units on the way, they wanted to try to seek their own justice. And and they rolled the dice. And now that they rolled the dice, someone's dead, and they should be punished for that, right? They should pay this guy's medical bills, legal fees, and everything, right? And for some reason, it seems like people just want this guy, or want these people to get off. But I think it's reasonable to believe that they should have to account for the things that they have done. They've done some horrible things, and they should be accounting for that.
I could go through the chat and answer some questions, but it depends on you, Alita, because it depends how deep you want to get sucked into this discussion.
we can do it for a little bit more. We can answer some questions from the chat.
Okay, so here's some things I can note. Tyler Durden asked, entry without permission is legal if the perp didn't break the door or window. No, we didn't say that.
No,
that would be a
it just means
trespass.
It just means it's not a breaking.
It's just not a burglary.
Breaking
Yeah.
in.
So yeah, we didn't say that.
Right.
Fox Adams said Terry stop is effectively a detainment. No one disagrees with you that it's detaining, but it's not an arrest legally because it's a Terry stop. So there's a difference between a citizen's arrest, which is an arrest, and a Terry stop, which is not an arrest.
Right.
Tyler Durden says illegal entry doesn't indicate intent. Illegal entry indicates that he's illegally entering. How do you know what his intent is otherwise? What evidence can you point to objectively? Because all you have, even from the video cam footage, let alone. So first of all, we could ask what evidence do they have? Because they don't have the benefit of that at the time. So there's that problem. But even assuming they were watching it somehow in real time, based on what you saw in the video, he walked in, he looked around for a bit, and then he left. How are you getting to intent to commit any other crimes?
Right.
So sure, maybe he committed trespass, but yeah.
Because then you would have to look at all of the other people that they have footage of these other people trespassing as well. Adult couples, children, etc. That you would look at them and say, well, what's the difference between them and him as far as their intent is concerned? How can anyone tell the difference?
How do you prove those two children that went into that did exactly
or the older
thing
couple,
that Arbery did?
Yes.
What's the difference between what they did and what Arbery did?
You have to show something more than just the fact that he was where he was not supposed to be.
And and it's sad because if this was a left-wing show, we'd be saying it's obvious what's the difference, right? But we're not saying that. We're just asking you what is your reasonable expectation of why is it different in this particular case, this unique case, but these other cases which you saw people going in, why is it different in those cases?
Right.
And then the people talking about castle doctrine. If you're in a home and you live there, that's a bit different of a factual posture than the home was partially under construction. We're not talking about a home that people are living in, okay? Be reasonable, guys. Let's just stay to what we are saying and not try to extrapolate it to all the things.
Yeah.
Right.
Sorry, I'm getting a little frustrated with chat. I'm sorry. I'll stop talking now.
It's good. I think it's good to explore, but
because it's I mean, this is part of what we do, right? We have to take these things apart and show that these are all individual terms. They are all individual concepts, and they don't necessarily bleed into one another. But I can understand how people can hear that they are similar enough that they might not know exactly where the border is between these various concepts, right? So it's good to go over it, even though sometimes explaining it can feel a little frustrating at times, Kurt.
It does. Sometimes it feels frustrating because people ask questions like, "I didn't say anything even like that. Where are you coming up with this?"
But if they are sincere questions, like I totally welcome them. I totally welcome them because I mean that, like I said, that is what we are here for, right? Is to sort of help people find where that line is so that they can understand this stuff and make sense of what's in the news. So was it a trespass?
Maybe.
Probably yes. Most likely yes. Was it a burglary? Most likely no, unless they have some kind of evidence of his mental state that he was intending to commit some other kind of a felony or to steal something. But they have to have evidence of that beyond the fact that he was just there. So as far as the citizen's arrest, they were not there when it happened. First off, it wasn't a felony, which is also that's also one of the things that I think is problematic with the old law, because you then have people trying to decide whether something is a felony or not. And obviously this distinction between trespass and burglary that a lot of people have confusion over has some salience as to why I'm not the biggest fan of the old statute. Because then you have your average Joe Schmo deciding whether an act is a misdemeanor or a felony without any kind of proper training. Yes. And then that just creates a huge risk for themselves.
Yeah, I think the problem here is that, on one end, I do understand the backlash, right? Because you see somebody going into a house, it's like, why should it be allowed to do that type of thing? And I totally understand that response. But in the legal sphere, you got children going inside there. You got a couple going inside there the same day. You have all these other people. Matter of fact, they were calling 911 on other people going inside there, right? So now now it gets to the thing where, either all those people, I think 50 or something people have all committed first, felony burglary and should be arrested and do years in prison, right? That's what we're saying, right? Because they're all on camera. You can catch those kids. You can catch those people. They've committed burglaries, right? But you know why that's not happening? Because they didn't commit burglaries, right?
Jason Howell says maybe he was casing the joint. Yeah, maybe he was, but what did he do differently than the white couple did or the kids did or literally anyone else? What did he do differently that would lead you to the conclusion that he was casing the joint and these other people weren't casing the joint? What can you point to? So how is he casing the joint and no one else is? What basis are you drawing that conclusion on? Surely it's not the color of his skin, right?
And someone else said, the other people didn't get caught. We see them; they're on video. They did get caught. They're on video.
We see them. We see them. We establish they exist. Okay, why are they not guilty? Why is he guilty and why are they not guilty? What did he do differently such that he is guilty and they're not guilty? Point to something different that he did. And no, it's just not there. He literally went in, looked around, and then left. He probably did the least of anyone who went in there, I'd guess.
The other two went in there and had a good time.
I don't know for sure, but if I was to hazard a guess, I think the kids probably picked up something at some point, to play with or something. Which technically I guess is a burglary because they've taken possession of something that isn't theirs. So let's go after the kids for 20 years for burglary, I guess.
And there's a comment in the chat too that the difference is children and a grown man, but children can
commit crimes.
They can commit crimes.
Children can in fact commit burglary. I'm quite sure.
Detention centers.
Yeah, children can in fact commit burglary. Quite positive of that.
And all the other adults that went inside there
the adults that went
children,
inside,
right? Yeah, they're not children either. But
probably.
But what is this desperation? And maybe it's just me. What is this desperation to make it seem different? Because when we're asking people how is it different, it's like there's no answer. But there is an answer. But we're trying to find out what is the answer. Is the answer something reasonable, or is the answer something kind of like something nefarious that people just don't want to say? Right?
That seems to be, and I hate to but it seems to be what's happening. Like especially with that guy who's so desperate. It's like you're trying to justify a lynching, basically, and I'm like, how are you doing that? Why not the white couple and why the black guy? Because he's black is the answer. I'm like, no.
Well, and this is a point that I really want to make is that looking at each of these cases that have been in the news, Derek Chauvin, Kyle Rittenhouse, this case, all of these cases need to be looked at individually within their own context, right? So you can come down on one side in one case and come down on a different side in another case, right? So like we all talked about the Derek Chauvin case, George Floyd case at length, obviously. And all of us were very much on the fence of how it was going to go because of the whole causation issue, and that was a much closer case, but But this one is very different. This one is a very different case.
And I'm also hardcore team Kyle Rittenhouse.
Yeah,
because I think he's getting completely cheated.
Right,
See,
exactly.
And think about this. And let's just be honest. There are a lot of people who are for Kyle Rittenhouse just because he's white. There are a lot of people for Ahmaud Arbery just because he's black. But we don't think in those terms, right? For Kyle Rittenhouse, me and Kurt have done the analysis, and we both believe Kyle Rittenhouse is self-defense, and he was justified in what he did. And it had nothing to do with him being white, and it had everything to do with the facts of that case. And in this case, based on the facts of the case and what we see, this was unfortunately a homicide by people who were trying to commit, what's it called, felony false imprisonment, and someone died. Yeah, and those are just the legal realities of it.
Yeah. Without
race, race shouldn't have to play a role inside this. And I think you can truly hold both positions based on the facts of that, because a lot of people think that this is this broad brush among everything, but that's not the way the law works. It's very factual in the context of that particular set of facts, and then you got to kind of forget all that and look at these new set of facts and reevaluate without that stuff that happened in the past.
Right.
All right.
Right. So I implore people to look at each case individually and to try to not look at it from, through a political lens, right? Because these are very fact specific situations, and you don't need to be political one way or another on these cases. You really don't. So
the three of us, our politics aren't the same, but we still try to analyze the same legally, and we usually come with the same answers.
Right.
Yeah.
Right.
We divorce the politics from the law.
Exactly. Because that's what it's all about, right? That's what you're supposed to do in the law, is to take the law. You've got the elements that they have to prove, boom, 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 boom. And then you've got the facts, and you say, okay, which one of these fit into these various boxes? And are there any boxes left that aren't filled? Or is there evidence over here that negates some other evidence in one of these boxes? That's the kind of analysis that you're supposed to do, instead of just these broad brushstrokes of the media says one thing, and so I'm going to say the opposite, for example.
Yeah.
Which as an impulse, I understand.
I completely understand it too. I
absolutely understand. The media has definitely cheated some people horribly.
Yeah.
The media has done some horrible service to some people in the past.
Well, it's doing it to Kyle Rittenhouse.
Yeah.
I think the
Kyle Rittenhouse.
Yeah,
I think
would
the media
agree.
The Covenant Catholic kid with
Yes.
the
The
Covenant
DC thing
kid,
that was very bad.
Yeah, no, that was horrible. That was horrible, because they took someone who was just in high school. He was just a high school kid. He was on a field trip, coming back home with his friends, and just the way that was just completely torn apart so quickly and so negligently by the media was just absolutely abhorrent. And I'm glad he got a settlement. I'm glad he took him to task, because that's exactly what should happen in those kinds of cases. So
Okay,
yeah.
Great. Let's move on.
Anyway, so that's what I have to say about that. Do you guys have anything else on this case before we go back to our favorite person?
Oh, no. This is it. I have maybe 20 minutes left, so before I have to run. Sorry.
Sure. Yeah, that's about same for me. We don't have to talk about it for too long, because I know that we talked about this case yesterday on Nate's channel. So anybody that watched it there is going to get a little bit of a repeat. Maybe a bit of an abridged version of yesterday, because we really went through the complaint that was not yet filed but served by Todd Chrisley
which somehow counts.
on Katie Joy Paulson, right? Because of course, as we talked about yesterday, the state of Minnesota has what is called hip pocket service, where you don't necessarily need to file it in court before you serve them. So, in fact, I think it's a requirement for all civil cases, right?
I don't think you have to.
No.
I mean, there's nothing stopping you from filing in the first place.
Okay. I was under the impression that maybe for civil cases it was an administrative requirement, like a prerequisite before you file. But this is basically a way that the two parties can have a brief period of time where they can potentially settle the case before it's actually filed and made public. it's kind of like this weird intermediate step between a demand letter, when the plaintiff sends the defendant a letter that says, these are all the things that you did wrong. This is what the law says. This is what I'm going to sue you for. If you want to settle, call me. Otherwise, I'll file a lawsuit. So this is kind of like an intermediate step between a demand letter and actually filing the lawsuit in court so that the whole world can see what the claims are. So, but we got access to the complaint because Nate got it from Emily D. Baker, who asked Todd Chrisley for a copy of it. So anyway, so
it's funny that Todd Chrisley himself wanted to share this disaster show.
I don't know if maybe he realizes just how bad it is, right?
I wonder if he realizes it now. Hope you're watching.
I don't know. I mean, I would not venture to guess that he would be watching my channel. Maybe Nate's. I think Nate's is probably big enough.
Did you guys go through? Well, I know you did. You couldn't go through it because you had the link. I don't know if you looked at it on Civil, the whole thing.
The complaint?
Yeah.
Yeah, I read it.
It
didn't get any better the second time.
Didn't get any. Because sometimes that happens where you'll reread it and you think, well, maybe this is a little better. But that one piece just really killed it. That whole no reasonable person. It's like, really?
Yeah. Which, I mean, as I've sort of thought about that paragraph. So we're talking about. So for anyone that is just catching up. So Katie Joy Paulson made a series of statements about Todd Chrisley, basically accusing him of extorting his daughter or trying to extort his daughter so that she would perjure herself to federal authorities about a case that he is being charged with, I guess, some sort of tax evasion liability. Whatever. So, and the way that he was supposedly extorting her was that he had a copy of a sex tape between her and someone that was not her then husband that he had purchased for $5,000. So those were the allegations. I am not personally saying that any or all of that is true. Just want to make that clear. But that she made a series of statements and a number of videos and tweets and that kind of stuff. And so we've got this defamation lawsuit where Todd Chrisley has to prove, because he is a public figure, that not only was the statement about him, not only was the statement false, but also that it was actually made by Katie Joy Paulson with actual malice. Basically meaning that she either had actual knowledge that the statement was false, so she absolutely knew that he was not extorting her with any kind of a crazy sex tape or anything like that, or that she was being reckless as to the truth about that. So basically saying that she, not unlike the Covington case, right? The Covington kids case, where you could totally argue that CNN was being reckless when they were running with a story that they didn't bother to fact check.
I go better than reckless, malicious.
Well, yeah, but yeah. So reckless as to the truth or falsity of the statement would be how that would be the lowest standard for malice in a defamation case. So one of the things that we were going through each statement yesterday, and we found that pretty much every statement that was listed there did not really seem to, at least in our opinion.
Yeah, the best we got was one where if I squinted my eyes and tilted my head just right, I was like, maybe there's something there. That was as close as we got.
Yeah. So there was only one statement that maybe could be defamatory, but because of the fact that there were other statements made by Todd Chrisley's daughter, no less, out on Dr. Phil, and apparently Katie Joy also has this friendship with the daughter as well, with Lindsay Chrisley. So there is this relationship. So trying to prove actual malice in this case is very difficult, because any reasonable person could rely on, for example, the Dr. Phil video, or if you have a friend that says, my dad did this to me, depending on your relationship with that person, I don't know. I could see at least on its face, my initial reaction would be, I can see how that would be reasonable if you are friends with someone and you believe something that they say about their own family, because why would they say terrible things about their family if it wasn't true? Obviously, there are plenty of reasons why someone could but depending, like I said, depending on the relationship that the person has. So anyway, so then we got to paragraph 26, and I will share this one.
Your reaction where you did this like head jerk thing, where like the moment it finally hit you, it was great. You did this like, it was hilarious.
So it's because I was a little bit distracted with the dog.
Yeah.
I will admit. And so, because she just kept she just really wanted attention when we were going over it. But it was not as good as Kurt's reaction, I will say. I mean, you seemed like you were going to have a stroke, Kurt. But so paragraph 26 is where we got to, where we had this crazy reaction, because the argument here, it says Ms. Paulson knew the sex tape statements to be false based on her relationship and regular communications with Lindsay Chrisley, the daughter. Moreover, the sex tape statements are so sensationalistic as to be improbable on their face. Any reasonable person would have cause to doubt the claim that a father attempted to extort his own daughter by threatening to release a sex tape and nude photographs involving her. So the problem with this is that this is something that a defendant would say, not a plaintiff. This is something that certain defendants have certain notable defendants have recently won on. So that would be what's his name? Tucker Carlson, thank you, and Rachel Maddow.
Yeah.
Yes. So, but one thing that I was thinking about is, do you guys think that it makes any difference here that this is a little bit more argument than factual assertion? I mean, it's still terrible.
Well, the thing is like in the Tucker Carlson case, one thing when I read through that case, Fox News essentially admitted defamation. They admitted, okay, we the things that he said were false, they were defamatory, but they were able to say it because no reasonable person thing. And I think here, if you're Katie Joy Paulson and responding, you do your general response, but then I think you definitely have to have that line that says, you go through the standard, hey, just like in Carlson, just like in Maddow, these statements can't be defamatory if no reasonable person would believe them to be true, blah, blah, blah. And then you say but this is a point that that both sides agree on here in their complaint, line 26. They also admit that these things were so, what would they put, so sensationalistic to be improbable on their face, obviously. Yep. And since, any reasonable person would have come to doubt the claims, then obviously this can't be defamatory by their own reasoning.
How could it possibly create reputational harm, right? Because that's an element that has to be met in defamation. So like I said earlier, when you allege any sort of claim in a civil liability case or in a criminal liability case, you have certain elements that have to be met. And every single one of those boxes has to be checked in order for the plaintiff or the prosecution, if it's criminal, in order for them to win. Otherwise, if there's a single box that is not checked, defense wins. So in this case, we've got harm that needs to be checked.
Maybe let's give an example, right? Maybe it would be something like if one of you guys said about me, actually, as it turns out, uncivil law is the leader of Antifa, or as it turns out, uncivil law is the leader of BLM. Okay, so that is purportedly a statement of fact, but no reasonable person should believe I am the leader of BLM.
Yeah.
So if you don't believe it, if you're like, that's not true, then you don't accept it as a fact, even though it was presented to you as a fact. That's a factual statement, but you're like, I don't believe that fact, so it's not a fact to me. Right. So yeah, it doesn't work.
So think of it also in terms of like satire, for example.
Yeah.
You can have Saturday Night Live can have a sketch that is completely lampooning some public figure and putting them in some sort of a compromising, situation in some sort of a sketch. And no reasonable person would believe that they are saying that this actually happened. Everyone would understand this is a joke. This is not true. This is not, this is not real. So therefore there could be no defamation in a situation like that. So it's similar to that kind of situation.
Yep.
Yeah. The sad part about the sad part about this whole thing is that he hyped it up so much, This is such a great case. I'm going to be suing her. Like the hype was real. And then at the end of the day, to more or less make her case for her, it just doesn't make any sense. It's just like, really, like you didn't, somebody didn't say, well, I don't think we can say that. Now I do want to say this. I do want to be fair to Todd Chrisley. I'm thinking he was trying to argue his way out of actual malice. So one of the ways you can argue actual malice is saying, well, this is so improbable that it's obvious that it was false, right? That it's obvious that it was false. And since it's obvious that it would have been false, then, the person should have known that
but
it was
if it's
false.
obvious it's false to them, it's obvious it's false to everybody. That's the problem.
Yes,
Right.
That's the so that's why you can't use that line of argument
Yeah, it
against
doesn't work.
actual malice, where
Yeah.
you can, and that's why you have to prove actual malice. You got to prove, it has to be something else. But this
Right.
improbability, just if reasonable people don't believe it, then you don't have defamation.
Yeah.
Apparently, Todd Chrisley's lawyer had to this to Emily D. Baker, said maybe one of us or Emily D. Baker should invite him on and be like, so could you please explain to us your 360-degree underwater hungry hippo moves of paragraph 26? Please, why are we not getting it?
When I read 26, I think 26 is trying to argue for actual malice, trying to say we have actual malice because this is as soon as they said this is improbable, I'm thinking they're saying this couldn't be true because just the nature of the claim. So that's actual malice because
Right.
who would believe it's true?
That does make sense. I think that probably was the intent of that paragraph because of that first sentence. How it says Ms. Paulson knew the sex tape statements to be false based on her relationship and regular communications with Lindsay Chrisley. So this is an allegation that she had actual knowledge of falsity of that statement, right? So that would if there was evidence for that, that would fit the box for actual malice. But the allegation says based on her relationship and regular communications with Lindsay Chrisley. What does that mean? You have to be a little bit more specific than that because
I don't know what that means.
Like, what about her relationship? Based on the fact that she has one in the first place, or based on the type of relationship that they have, or
but read that.
I don't even understand what that sentence is supposed to mean.
But I think you have to, if you read that first sentence in context with the other two, I'm thinking this is, in other words, the first sentence is this is what we're going to prove, that she had actual knowledge because of the relationship. And how does that prove that she knew this was actually false? Because they were so sensationalistic that no reasonable person would have believed them. So that's what I'm thinking. I'm thinking that's the line of reasoning, even though I agree with you guys, it just not work. I'm just trying to give them the benefit of the doubt with the reasoning.
I think the way to write a paragraph like that, to have it actually, make contact between the bat and the ball, would have been if they had said something about no reasonable person who is familiar with our family, who knows our members of our family personally, could have possibly believed this, because they're trying to get there with this relationship, that she has a relationship with Lindsay Chrisley. So if they had said something like, she has a friendship with Lindsay Chrisley, there's evidence of previous times when Lindsay Chrisley has lied to Katie Joy Paulson about other things, or something like that. At least that would kind of sort of start to tie that patchwork quilt together a little bit, and to say, because she knows the kind of person that Lindsay Chrisley is, and because she's a terrible liar or something like that, and because she also personally knows other members of the Chrisley family, no reasonable person that is friends with our entire family would have possibly believed this thing.
Okay. Yeah. If that was what they were trying to go for, then fail.
But they didn't do it.
No.
Yeah.
No.
So that's still, I still would, if I were Katie Joy's attorney, I would still be concerned about the possibility of Todd Chrisley's attorneys being able to amend the complaint if it is dismissed on a motion to dismiss. If the judge
I'm not
would give,
I'm not sure about that,
because,
but I think you might be right though. Just go to answer.
Yeah. Because of the fact that on argument on the motion to dismiss, at the hearing in front of the judge, his attorneys could say, "Look, this is what we were trying to get at, and we didn't do it so artfully. So give us a chance to amend it, and then we'll rewrite it." I wouldn't even give them that chance. I would file an answer as lickety split as possible, and then as soon as possible after that, file a motion for summary judgment.
You're trying to
File a
get
motion
this
for
dismissed on the
sanctions while
merits.
you're at it for bringing an obviously frivolous, because you yourself argue it's frivolous. So bring a motion for sanctions while you're at it. Get some attorney's fees out of it. That'd be good.
I don't know. Do you answer or do you send? Well, I would definitely answer. That's
Yeah.
no doubt about it. I would definitely answer. But then after the answer, I think because you could still because you can't really waive, because this is for failure to state a claim, right? This is essentially failure to state a claim. So
Yeah.
so and I don't think that can't be waived, right? If you just don't have a good case, you can always re-raise a failure to state a claim. There are some
Yeah,
like
because it's
statute of
summary
limitations
judgment. It's
you
like
have-
you still don't have a case. Yeah, exactly.
and with like statute of limitations, you have to raise that or you lose it. But this, I don't think you get. If you just don't have a claim, you just don't have a claim. So I don't know. Because essentially what you're saying is you're trying to get the dismissal on the merits, and you want to be dismissed with prejudice and not without prejudice, and the claims to go away. It's possible, but I don't know. I think it'll be tricky because you have to kind of go really far down the line, I think, and you're talking about maybe even going through discovery or limited discovery to get to that point, which I don't think I would want to do.
Oh, yeah, well, you file the answer and you file a motion for summary judgment, and you call you call it a day.
Yeah. That's the route that I would probably go, just to put a nail in the coffin, make sure it doesn't zombify itself and come back.
Yeah. Well, but I think all the claims all the claims with the daughter and the show, I think those are all nonsense. Those will get thrown away because of the Dr. Phil show. I think the second claims may have something to it. Like, she said that, I was extorting her. You may be able to get something out of that. I don't know how the court's going to judge that one. You can get something maybe, but I think it's less likely. But it just we'll see. I think the first step of claims is good, or for sure filed dismissal. The secondary claims, I think, may need a little bit more.
Right.
If I were filing this answer or motion to dismiss, the only question in my mind would be, should I be a good lawyer or should I be an incredibly sarcastic, mocking lawyer?
Brown. It should be Brown, right? Turn into Brown.
And I'd be like, well, not necessarily insulting the other attorney, but just insulting their entire case. Like, how should this be like really professional, or should it be openly mocking and disparaging because of how crap it is? What do you think, Legal Bites? Which is the better course of action? Help me out.
I don't know. The most that I have ever done on any kind of a filing in any lawsuit is anytime I'm quoting another, the opposing side on something that they said in an argument, you put it in quotes and you find a typo and then you add in sic, S-I-C, that basically indicates the misspelling is not mine, it's theirs, and it kind of flags it. That's the most that I've ever done if I was really annoyed
How about
with the other side.
affirmative defense 1, ha, 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 ha. And then we'll get an affirmative defense 2.
Oh man, but I would gleefully write in response to paragraph 26.
Yeah,
but
see,
agrees.
you're my boss. If effectively, because my boss does this to me all the time. It's like, because I want to always do this scoring stuff. He's like, no, we have to be professionals. I'm like, you're paying me. That counts.
Yeah, I mean, because it's like, it also kind of depends on the judge, right? Because what level of humor are they going to find in it, or are they just going to think that you're being unprofessional? And the next time you have a case in front of them, they may be like, this guy's unprofessional. I don't know if they know what they're doing.
Yeah, maybe.
Kind of like typos. This is why, I was, yesterday I pointed those out, how they misspelled Lindsay a couple of times in the filing, and which is embarrassing because that's the plaintiff's own daughter, right?
Yeah.
But and I know it's nitpicky, but this was ingrained in me by my bosses from an earlier stage, that those kind of details matter because they show that you're either paying attention to details or you're not. And as soon as you have like one typo, okay, fine. But once you start finding multiple typos in there, then you start to think, does this person really know what they're talking about? Are they citing to good law? Let's double check on this stuff.
It's like somebody in the chat keeps saying like KJ claims to be a reporter. First rule. So okay, so she's claimed to be. I think Sean Hannity claimed to be a reporter at one point in time too. And when somebody's trying to get him. But the thing is that they're going to look at the context. They're just not going to say, oh, she said that one time, that means she's a reporter, right? They're going to look at the context. What is she covering? What is she usually saying? Oh, she's covering TLC stuff. Oh, she's always giving her just the opinions. This is an opinion show, right? I don't think anybody would say they're going to her for a hard news show. They're going to say this is an opinion show, and she writes on everything.
I'm not quite sure. I'm not quite sure how her being a reporter matters either way.
Yeah.
So it doesn't do anything for me, but okay. I don't think reporters get special First Amendment analysis. That's my view.
Well, I think they're saying that since she said that she's a reporter, that automatically kind of grants her this whole thing about being what's it called? That she's giving facts and not opinions, because reporters give facts, But if you think that, watch CNN, right? Watch Fox News, right? And, they do give opinions. So the analysis is a little different.
You can still have a reporter that writes an opinion column.
Yes.
And they say this is an opinion piece. And so that person is writing an opinion. So, even if she has called herself a reporter, like you guys said, the actual substance of the content itself is what matters most. So whether she calls herself a reporter or not, if what she's actually giving is effectively commentary and opinion, and she conveys it in a way that people would understand that it is commentary and opinion and not just fact, then that's what matters most.
Yeah, please show me a person who thinks what Katie Joy Paulson says is gospel. That doesn't seem to be the zeitgeist.
I think a lot of people don't understand too the argument here, because I understand she's pissed off a lot of people, and they want revenge, and they want great, right? Do it. But I think on two separate pieces, you have to think. Number one, I think the anti-KJP crew, they always say you can't believe her. She's always lying. You type her name in, and a whole bunch of things about her lying, right? She's lying about everything. Now you're going to say, well, people believe her lies, right? But that's not true. We know that you guys can't have it both ways. You can't say that nobody believes her. She's an idiot. Nobody believes her, and then on the other side says everybody believes her. No, it doesn't work that way, right? We know her reputation is going to come into play. That no one believes her, that nobody takes it seriously, that no one thinks that she's telling the truth. And if you put all those together with, and a lot of the people probably who hate KJ have written those things. Go to Reddit, go to this. And
that actually could really help her.
Yeah, the entire Without a Crystal Ball, subreddit is doing God's work for her at this point.
It's like, okay, look at this. I got thousands of people. Everybody knows that I'm not giving out facts. Now all of a sudden he's saying I'm giving out facts, right? I'm a reporter. Come on, it's you can't have it both ways. And I know it sucks, because I know people are like, this sucks, but that's just the way it works.
Yeah, it's true. And look, I mean, this reminds me of some conversations that I had at times with potential clients that we had to turn away that were in employment cases, right? Where they were talking about the terrible conditions that they had working at their job. And I was like, okay, did you ever complain about something? Did you ever ask for some kind of a holiday because of your religion or anything? And they were just like, no, I've just had this terrible time and my boss is an a-hole. I'm like, okay. So I've had to tell them, it's unfortunately, even in California, it is still not illegal for your boss to be an a-hole, right? So if you think that Katie Joy Paulson is a terrible person, still, as of yet, that is not illegal.
That is not illegal. Thank God.
So until, unless there's something specific that she does that you can find some civil statute, some criminal statute, and that it checks all the boxes, we're not there. And this case is not it. So, and you know what? Like, if somebody files a case against her and we find, hey, actually, this is a pretty decent case, we'll say it. We have no dog in this fight. I don't even watch her stuff.
How good for my channel would it? How good for my channel would it be if I could post a video that said Katie Joy Paulson is going down? That would be great. This is the end. Yeah. How good for my channel would it be if I said this is a total loser for Katie? She's going down. This is the end of Without a Crystal Ball. How good would that be? I'd love to make that video. I can't make that video. Please, someone find something that would allow me to make that video. That'd be great. But as of yet, does not exist.
Yeah,
she hasn't done anything wrong. I'm sorry to tell you.
Yeah, the algorithm
no.
really would love that.
Yeah. Well, because I won't even say she hasn't done anything wrong. I'm just saying she hasn't done anything wrong that is legally relevant where I can say.
Right.
Well, that's what I meant to
Right.
say.
Yeah,
You know
right.
that.
Yeah.
I think
Well,
I thought that was clear from the context. I wasn't making a moral judgment.
Listen, trust
Yes.
me. There are people who will
Okay,
click
yeah,
that,
fair point.
And then,
fair
and then
point.
they'll say, "Oh, look at that civil law said this."
Fair
about it."
point.
Like, oh my God.
Yeah, no, I wasn't trying to make a moral judgment. I was trying to make a legal judgment.
Right. Because
Oops.
I mean, there's a reason why people have, I guess you could say divided opinions about her, but yeah. So as of yet, I don't see anything in this case that she really has too much to worry about, so long as she's got good representation that can make some good moves. But they've got at this point, because Todd Chrisley's lawyer apparently missed it. So if Katie Joy's Paulson's lawyer misses it, then that was
that'd be
complaint.
interesting. I'm not sure which would drive me more crazy. Yeah, I'm not sure if it'd drive me more crazy that Todd Chrisley did this or Katie Joy's lawyer misses it.
No, but but the good part, sometimes the judges will catch it and be like, well, even like the plaintiff, it argues, no reasonable person would think this was fact, So sometimes even if you do miss it, the judge's reasoning will be, because again, I'm assuming if my response to this, if I was KJP, would kind of hit three things. Number one, commentary channel, I'm just like Tucker Carlson and Rachel Maddow, right? Matter of fact, they look more news-like than I do, right? I'm in my home sitting in front of my couch. They're on, the thing is Fox News, right?
Truth.
Their opinion shows, right? So number one, right?
Yeah.
And number two, here's Tucker Carlson saying someone extorted somebody. Here is Rachel Maddow saying that this is literally Russian propaganda and these are Russian agents, right? Those cases were dismissed. Matter of fact, in the Rachel Maddow case, it was so bad that they won attorney's fees, right? And what's the standard in both those cases? The fact that no reasonable person will watch an opinion show like theirs and believe that they were talking about, that they weren't spouting opinions. Guess what? I have an opinion show. And just like the plaintiff says, no reasonable person would think that these opinions on these facts. Boom. It writes itself. Itself.
Yeah, it really does. Anyway, well, I think that for me, it just about does it.
The only other thing that was worthy of legal news was Duggar had his motion to throw out the evidence denied by the judge. So that was interesting.
Man. So I actually have not been paying as much attention to that case, but I know it's been big in the news.
I just
gotta
go? I gotta run. Yes, it's at that time. I have 2 minutes before I jump into the call. Thank you guys.
Thanks for joining us. If you guys don't already follow him, subscribe to Nate's channel. Go check out his locals. Join his locals subscribership there.
Nate the lawyer at locals.com. That's
Nate the lawyer at locals.com.
Later, guys. Enjoy.
All righty. See you, Nate.
Josh Duggar is being accused of possession of prurient photos of youth. Yes. And
prurient photos of youth. That's a good way to put it.
Prurient photos of youth, yes. And so he filed a motion to have the evidence thrown out, which, you would expect, to be honest. And the judge denied it, that the search was proper and all that good stuff. So, yeah, the evidence can still come in against him. So that's not going to end well for him.
Yeah.
So.
Yeah, most likely.
No.
Oh, boy. Yikes. That is I haven't covered that one because it's a little icky.
It is a little icky. It is a little icky.
Yeah, but it is still important for cases like that to be covered because people like that unfortunately do exist, that's a rough case. Are you covering it? Are you making videos about
Not
that?
particularly. It's just something else that was notable that happened in the news this week because you did a little rundown at the beginning. So I was like, oh, here's something else notable that happened in the news this week.
Yeah.
So I mentioned it.
Yeah. So, man, what else? I mean, yeah, there's been a lot going on recently. The one thing that it's like because Britney Spears has finally slowed down. Now there's like this explosion of like other stuff.
Yeah. The Britney Spears case has been really interesting and just trying to understand what has been happening. And then the next logical question is, did something go wrong previously in this case? Did her lawyer fail to make the right arguments? Was she not properly represented? Yeah. Were mistakes made prior to this point? Because you're looking at this and you're like, okay, this makes sense for Britney's argument, but it also kind of makes sense in the past, because I saw one interview at least from someone who does conservatorship cases, and he said, never in my life have I ever had a conservatee who had a job.
Yeah.
And not only does she have a job, not only is she not like working at the dollar store or something, she is a multi-millionaire performance artist who at one point was having a residency at Vegas, like performing shows basically every night. She has to work with people, train dancers, work on choreography, practice, technical aspects, the show itself, do that every night. People love the show, so she's obviously doing it well. So, okay, seems like a very high-performing woman for conservatorship. So, okay, was the conservatorship justified at the very beginning? Maybe, although, but maybe. So let's take the premise it was justified at the very beginning. It feels like somewhere along the line, someone wasn't paying attention or made a mistake, and this should have ended a long time ago. Because the moment Britney says, I want this to end, the whole thing starts. So it's like, why didn't that happen years ago, either through her attorney or otherwise? It's very odd.
Yeah. I think it's kind of like that, I think it was the Thomas Paine statement, right? Power corrupts. And so absolute power corrupts absolutely. So once, I have a sense that the conservatorship probably maybe was started with a sincere concern for her, because there was so much going on in her life and things were genuinely very chaotic at the time. Maybe that's at least me looking at the situation, a little bit optimistically, at least but if that's the case, then I think that probably what happened is that as soon as there was control over her life, certain forces in her family and maybe elsewhere around her, people said, well, you know what? This is a pretty good deal. Let's keep it going. Turn it into a hybrid business.
Especially when Jamie Spears was paying himself more salary than he was allowing Britney to have.
Which is ridiculous.
What I'm doing is worth more per year than the stuff you're doing.
Yeah.
It seems odd.
Yeah.
And then I also, when they started trying to attack the proposed conservator, the new conservator, it's like not being qualified. I'm like, what are you even trying to do here? How is he less qualified than you, this forensic accountant CPA, to deal with finances? And you've been dealing with these,
Yeah.
So I think probably what happened, what probably happened, let's just go with the most optimistic version of this. It all started with good intentions. At the beginning, everything was fine. Jamie Spears was doing his job perfectly fine. All was right in the world. And somewhere along the way, he started making compromises, as criminals do, right? It usually doesn't start out with the biggest thing right away, it usually starts out small. And it starts escalating. And basically, at some point, it escalated so much, he couldn't stop doing it, because he basically banked his own reality on it existing. And now he's just been trying to save himself for fairly rational reasons to try to prevent the whole thing from being unwound. So he has become incentivized by his own motivations to prevent this all from ending.
Yeah.
It's like he wants it, and if it's going to end, he wants it to end cleanly. It's like let's come into an agreement with an immunity, so I can't be sued. Let's come some sort, so we don't have to go back. Because if we're going to go back in time, which we might wind up doing, as Jamie Spears is probably thinking to himself with some justification, this could absolutely ruin me. I might be left with nothing more than the shirt on my back. Yeah. So, yeah.
Which is the nuts thing about it. To me is, I've done estate planning. I've created an estate plan for many people, and I've talked about conservatorships with many people, and I have also done conservatorship cases myself. And the benefit to doing a power of attorney or, an advanced medical directive is that you are able to, say who your agents are going to be and who they're not going to be if something happens to you, and it's all left out of the court. You don't have court oversight. And so sometimes in some cases, it's actually better to have a conservatorship, because at least that was my judgment anyway, was that sometimes it's better to have it in a conservatorship, because then you've got court oversight for something, in a situation where no one in this person's life can be trusted. Sometimes that is better. But cases like this make me think twice about that, because now you have a situation that had court oversight for, I mean, how many years now, right? Like 13 years. So, and still there's a lot of funny business that's going on, because I don't know, because the courts are impacted because they have too many cases that they're going through. And so they're trying to just stamp their way through them. I don't know, but something like the accounting really should have a decent amount of oversight if the court is looking over it. You know what I mean?
Yeah, and for Britney Spears' case to get lost in the shuffle, like, it seems weird too, because you could totally see from burnout, which I totally believe in, because like, why would anyone want to do this as their full-time thing? It's like, please don't make me a family court judge. It literally, anything else will be fine. But so you could see the judge being burned out. You could see the attorneys who are appointed being burned out. So if this was just a normal person, you know, and the court was missing it, like, it doesn't make it better, but it makes it a little bit more understandable of how that happened.
Right.
You know, just another number. It's just another statistic.
Yeah.
It's slightly difficult to believe that the court wasn't paying any more attention to Britney Spears. It's just another person. Like, really? You didn't raise your eyebrows at all, and you weren't like looking at this a little bit differently every single time? It's just another cog in the machine. How worn down are you? How worn down are you at this point? Maybe you should quit. Maybe you should find something else. I don't know.
Yeah.
Please don't make me a family court judge, Alita. Please don't.
Well, and technically this would be probate court anyway. So not
either way.
family court. But
either way, I don't want to do it.
I mean, honestly though, I enjoyed the work that I did in probate court, to be totally honest, you know, including conservatorship cases and that kind of stuff, because, you know, it's not all terrible, right? This is one of the terrible cases. And there are other cases where people are legitimately being abused outside of the conservatorship and within a conservatorship. That absolutely is something that is happening. How we get to the solution is another thing.
Now, I once heard or read an article along these lines. So since you have some contact with the field, have you ever heard allegations that nursing homes will try to create conservatorships for their own patients and get themselves appointed as the conservator of the patient's estate, basically, to make sure that they will never leave? Have you heard of that being a thing?
I have not heard of a specific case where that has happened, but it wouldn't terribly surprise me.
Yeah.
It would not. I mean, especially where you've got to, you know, most of these cases where, whether it was a conservatorship case or a trust case, the cases that I thought were the ones where the person who was either in the conservatorship or was the trustee, or, you know, the original trustee of a trust, the kind of people that were most vulnerable were the ones that were maybe recently widowed or not so recently widowed, and their kids are all adults and they don't live nearby. And so they're kind of are reliant on other people around them to take care of them. And sometimes those people don't necessarily have the best motives. Sometimes they do. There are still good people that take care of the elderly.
I assume there's many good people who take care of the elderly, and we only hear about the bad cases, but, you know,
right.
Like, but kind of true of everything, but yeah, it's it's discouraging.
It's the case where, you know, you've got, you know, mom and dad that are in their 80s or 90s, and one of them passes away. And so, you know, let's say it's most often that I've seen, actually, it's the wife passes away first, and then the husband is, I guess, a bit vulnerable, a bit lonely, and he finds some younger woman just kind of waltzes into his life as a friend or as a romantic partner or something. And, you know, if they get married, she very often has a lot more rights to his stuff than otherwise. And there are all kinds of weird, vulnerable situations that can happen. So, yeah. So as in terms of, so relating back to your question about the nursing homes, it would not surprise me at all. It would not surprise me.
Yeah. I tell you, I don't know if this is how people evaluate this for themselves, but I'll speak for myself, and you can comment if your feeling is different. But I feel like my own sense of independence is a really paramount concern to me. I've commented before that, you know, I would not seek particular treatments if I thought it would potentially put my own independence at jeopardy. So even at the expense of potential health considerations, I think that it's like I really kind of full throat of give me liberty or give me death, and I take that to perhaps an extreme. But the idea of me being as a conservatee, the idea of me being, not being independent is truly horrifying. So I don't know if you feel the same way about that or not, but yeah.
I think that for me, what matters most is having things like a power of attorney and an advanced medical directive in place, because whether you like it or not, the law does exist that is the default, is that if you don't have those kinds of documents that make those specifications, the default is then that you go under a conservatorship if the court determines that you are no longer able to make decisions for yourself. If you have dementia, for example, or you're in a coma, I mean, that's just the reality, right? So I would just, make sure that I've got documents, they're updated. If God forbid my husband and I ever divorce, not saying that's happening, I don't plan on that happening, but updating your documents after an event like that. Do you somewhere have a file already for if case of emergency break glass? Do you have that file? No, absolutely not.
How good is your planning ahead, Alita?
No. It's not that far ahead, because that would be definitely putting the cart before the horse. But that would be more a little bit concerning. If right.
We're in that posture, like, what's going on now? It doesn't mean anything. It means something.
It does, but no. All it takes is just redrafting the document. You can even do it yourself with a Word document. Just kind of retype everything and change that detail, print it up, go to a couple witnesses or a notary if that's, depending on your state, because different states require.
Can my living will say something like F off? Can it say that?
I mean, it can say, in this situation, I would want X. In this situation, I would want Y. I mean, but that's why you would have this kind of, especially for an advanced medical directive or a living will, because a living will is technically like end of life decisions, right? Yeah. So that's why you would.
I'm never going to die, Alita. I don't need one.
That's usually the kind of thinking that gets somebody into a situation where they end up needing one. But yeah, that's why you would have a document like that, right? Is so that you can outline all of those decisions and say,
no joke. I'm seriously, I think I might actually go for cryostasis when I die. Go with the like Alcor Life Foundation, have my body put on ice in the hope that someday science will be able to revive me. Seriously, I might go that way.
You would be the kind of person that would say, upload my consciousness into a computer, even if my body's dead. Put me into a computer and upload me.
Why not, man? There's so much to do. And new knowledge is being invented all the time. So, I doubt I would get bored because there's so much happening all the time. The rate of knowledge being created is so high. So, yeah, I could become an expert.
If you're hooked up to a computer,
become an expert in all the laws.
Faster.
Yeah, become an expert in all the laws. And then once I figure that out, I don't know, I guess I'll become an expert in all the medicine and an expert in all the... the true Renaissance man. It'll be fun, and then I'll have the most comprehensive channel ever. I am the expert on all things.
To quote Mean Girls, the limit does not exist.
Yes.
So, anyway, now with that, I think we've cooked this steak long enough.
Fair enough. I had fun.
Yeah, this was great. Thanks so much for joining me, everybody who's still watching. If you haven't already, be sure to check out Uncivil Law. His YouTube channel, and now you have locals.
Yes, I do, and I'm going.
Do you have a community up?
I do have a community up. I do have a first post up, and my tentative working plan for what I'm going to be doing with it is I'm going to be putting unedited versions of the edited stuff for time. So my
Nice.
working intention now, I have to do some more editing. So I've got like about 10 videos still in the old style left that will go out. And then after that, I'm going to go with a format that's going to be like between 15 minutes. And so then I'll take the original raw one and put it up on locals for people who want the like more full experience. So that seems like a logical thing to do. Nice.
What I just started this week, actually just before the live stream, I uploaded for the people that are supporting me. They can watch my uploads of videos without any ads. So if you are a supporter and you hate ads, you can watch it there. So
or you just get an ad blocker like any normal person.
Okay, or you could do that, but that doesn't help you and me when it comes to AdSense. Anyway, alrighty, so that just about does it. So you can also see here my locals page if you guys aren't there already. And if you enjoyed this and you haven't already, be sure to like the video, share the video, subscribe to the channel, hit the notification bell so that you can see when I have new uploads on the channel. So, and with that, that'll just about do it. Have a great rest of your week and a wonderful weekend. And we're heading into the end of October. Also, before we head out, go Dodgers. I hope they can pull out a win against the Braves. Sure. I'm a big Dodgers fan, so pulling for them. Anyway, okay, with that, bye.